It's very exciting. Let's see. And then if we get Zoom bombed, then everybody will enjoy that. Okay. All right. Now there's two issues. One is a motion to enforce settlement, and then there's also an issue of a motion for summary judgment, which I've also reviewed. And since you all are planning on possibly trying this case, I think we need to deal with both issues, because I think Friday you were required to do a pretrial order, and I don't want you all having to do that if I'm going to grant a motion for summary judgment. So does that make sense that we take care of both issues today?
Yes, Your Honor.
Okay. Mr. Davidson, does that make sense?
Yes, sir. No
Okay.
objection.
All right. Good. All right. So the motion to enforce settlement, that's let's see, that is a plaintiff's motion, I think.
Yes, Your Honor.
All right. So go ahead.
Thank you, Your Honor. And we believe, the motion to enforce settlement, if granted, would dispose of the motion for summary judgment. So just briefly, the facts here: Progressive sent plaintiff an offer back in July of 2021 to settle this case for a specified amount of money, and there were no conditions placed on that offer. So in January, the plaintiff accepted that offer, and the acceptance was clear. It was unequivocal. We sent Progressive a letter in writing to accept that offer. And it wasn't until after the acceptance that we hear from Progressive that there was allegedly a phone conversation 3 years ago between an adjuster and Mr. Sedgey that the offer was rejected. So I have a case out of the the Supreme Court, Your Honor, the Georgia Supreme Court, Brumbelow versus Northern Propane Gas Company, that says, in the face of a challenge of a party to the terms of a settlement, where the opposite party has relied to his detriment on the agreement, the absence of a writing will not render the agreement unenforceable. So here we have a set of writings in this case, an offer to settle the case without any conditions for a certain amount of money, and a clear and unequivocal acceptance in writing to settle the case for that amount of money. Then we have, after that, a purported rejection based on a self-serving affidavit that, Your Honor, we would object to the validity because the affidavit is not dated. So we don't really have any assurance that the affidavit was signed in the presence of the notary. And this is, Your Honor, why we do things in writing. Progressive could have provided plaintiff with its understanding in writing at that time that the offer was rejected. And we often do this as a policy. When we reject offers, we'll do so, and we might have a phone conversation and then follow up in writing. That's the important purpose of having writings, particularly when it comes to agreements. And we have another case, Your Honor, out of the Court of Appeals. Oral agreements may be enforceable, but that is only if they are undisputed. If the existence of the agreement is disputed, then the settlement may only be established in writing, and that's Walker versus Lewis out of the Court of Appeals. So we have a set of writings here, Your Honor, that clearly establish an agreement between the parties, an offer to settle this case for a certain amount of money, a written acceptance, and then again, a purported rejection based on an affidavit that was written 3 years after the conversation that is not dated. And so finally, there's another case out of the Court of Appeals, Thomas versus State, that says a witness may testify to his own intent or purpose, but not that of another. So there are some questions about whether the adjuster would even be able to testify about the intent of another party to a contract where the agreement is clear, it's unambiguous. We have a written offer with no conditions. We have a written acceptance in writing. So, Your Honor, it's our position that this case has been settled.
All right. Well, help me out on the timeline a little bit. The case was filed in like when? Because I know the incident was in 2020.
Sure. So we filed this lawsuit, Your Honor, in October of 2021.
Okay, October 2021. And then Progressive made an offer of settlement it's my understanding prior to the filing of the lawsuit. Is that right?
Yes, Your Honor, and I can provide that offer to you, but there were no conditions regarding this as an offer conditioned on you not filing a lawsuit, conditioned on settlement prior to a lawsuit. I mean, there were no conditions on this offer, and we get plenty of offers with that specific condition. This offer is conditioned on not filing a lawsuit in this case.
Got it. But so when was the offer made prior to the lawsuit? It was in 2020?
The offer was made in July of 2021.
July of 2021. Okay.
Yes, Your Honor.
And
Well,
I have a full timeline that is stated out in one of the documents I filed, the defendant's opposition to plaintiff's motion to enforce. I have a full-fledged timeline of when everything happened, like in order.
right. Okay. Yeah, that might be helpful. And I haven't seen that. I've read the responses and all that, but missing was a lot of the specific dates. So, but the law is also clear that if an offer is made and there's no conditions on the offer, that it needs to be accepted within a reasonable amount of time. Now, what's a reasonable amount of time? That's open to some discussion, but also if an offer is made and then there is behavior that is inconsistent with the offer, i.e., you make an offer to resolve a case, there is no response, and then you file a lawsuit, is that filing of the lawsuit after the offer has been made, actually filing it 3 months after the offer is made, is that behavior not inconsistent with acceptance and certainly consistent with rejection?
Well, Your Honor, I'll say in our office, oftentimes we'll have pre-suit offers that get accepted after the lawsuit. So it's not necessarily we filed a lawsuit and that is a rejection of the offer. It's simply keeping the door open.
Sure. Okay. Well, okay. I guess I could see that. But then the acceptance, you're saying the acceptance of the offer that was made in July of 2021 was done when?
In January of this year.
January of 2023. So we're talking a year and a half.
Yes, Your Honor.
Right. Okay. A year and a half after the offer was made. Okay. All right. Anything else on the plaintiff side?
At this time, no, Your Honor.
Okay. All right.
So our position is that we don't dispute the fact that there was no written communication that explicitly stated we rejected the offer. Our position is that, when they had the November 11th conversation, quite frankly, my claim examiner took that as a rejection. And she's like, I didn't feel the need to send out a letter because it was very clear that this offer was rejected. And going on what you were saying, that this isn't a case where it's just like there was a single conversation where there was a rejection. This is a case where they filed a lawsuit. They incurred a cost to serve our defendant. They had a course conversation with our claims examiner, which is provided in her affidavit, which the notary had dated the affidavit. So to the extent that it's not dated on the actual date line, the notary did date it when it was signed. And as we know, notaries have to be in the presence of a person to properly notarize an affidavit. She noted in the computer system that this conversation took place. And after X amount of days, these notes can't be, altered in any way. So, and quite frankly, the plaintiff's attorney should know that this conversation took place because they were involved in it. So at that point, there was no meeting of the minds. We have been operating for a year and a half. We went through depositions, we went through motions, all under the guise that this initial offer was rejected. And importantly, throughout that entire litigation process, there has been no email communications, claims communications that has somehow put this pre-suit offer back on the table, because from the get-go, when the first attorney got the file, they said, you know, this is kind of bleeding into the summary judgment, but this is a workers' comp issue. So at that point, we were intentionally not putting any offers on the table because we took it as a rejection from November 11th in blatant terms and have been operating under the guise that it is rejected since that date. And it wasn't until after we filed the dispositive motion that they said, oh, yeah, there was one written communication from a year and a half prior, and that should constitute like a continued offer on our end.
Okay. All right, Ms. Davis Campus, you have you want to respond? You get the last word.
Sure. Yeah, a couple of things. As far as the timing of the acceptance, again, I would go back to this point that there were no conditions on the offer regarding expiration of the offer. So it was our understanding that the offer remained open and there is no written communication suggesting, and as Ms. Rodriguez pointed out, there was no written communication regarding subsequent offers that would have made it clear that there was a rejection in this case. So it was plaintiff's understanding that this offer was open, it was on the table, and it was accepted in January. As far as the timing in conjunction with the motion for summary judgment, it's just not relevant, to be honest, because there were no conditions on the offer. Progressive could have put a condition, a time limit condition on the offer. They didn't do so. And then as far as notes, you know, a notation in the computer, we've not been provided with those notes. Now, I know we have an affidavit. Obviously, we object to, we have some concerns with that affidavit, but I mean, there could have been a recorded statement. We don't have any recorded statement. We could have been provided with notes. Our authenticity of those notes, we don't have that. So, you know, it's our position that this case is settled.
Ms. Davidson, did you, I didn't mean to skip over you. Did you have any dog in this fight?
No, Your Honor, I don't. Fortunately.
You seem pretty happy about that.
I'm okay for now.
Okay. All right. Anything else? Well, it would have been, I think, prudent on the part of Progressive to put some kind of a timeline, just as a normal course of business, any kind of an offer, some kind of a time deadline for acceptance on any of the offers. But since that wasn't done, then the issue is, was it accepted in a reasonable amount of time? And was the behavior of the plaintiff consistent with either rejection or acceptance of the offer? And I think based on the undisputed facts, it's clear the plaintiffs did not act in a way that was consistent with acceptance of the offer. They proceeded with the trial, with discovery, and so in the court's view, their behavior was consistent with the rejection of the offer, even if they had accepted it. I find that a year and a half after the offer is made is not within a reasonable amount of time. I think they could have accepted it a lot sooner than that. They didn't. And so based on their behavior and based on the timelines that I think are pretty undisputed, I find that there is insufficient evidence to support that there was in fact a offer that was accepted within the reasonable amount of time. And so I will deny the motion to enforce the settlement and will consider exceptions to the court's ruling, continuing objections for purposes of appeal. Then the next issue, so anything about that? Anything
At this time, no, Your Honor.
Oh, okay. Then now let's talk about summary judgment. Now, I read both sides of the issue, and it seems like the issue is, did Amazon own the parking lot that Amazon is located in? And apparently that is a fact that is maybe an issue, maybe not an issue. But if it's clear that if Amazon, and correct me if I'm wrong, but it's clear if Amazon owns the parking lot, which I think likely, then the egress and ingress rule for workers' compensation would apply, and that the sole remedy in this case would be workers' compensation. Now, since the motion for summary judgment is a defense motion, I'll hear from the defense first. And I'm sorry, for the court reporter's benefit, and I should have done this already, but for the court reporter's benefit, this is Nathaniel Gaither, plaintiff, versus Brittany Thompson, civil action 2021 V 53610. Just since we're putting this on the record, I should have done that in the beginning, but I've done it now. All right, Ms. Rodriguez.
Yes, so I think we both agree about the whole workers' comp ingress egress rule. So I'll just jump right into what you were going. Defendant's brief was saying that there's no evidence that Amazon maintained, controlled, or otherwise owned the parking lot. And they said that we need some kind of, Amazon managerial employee. There's no requirement that we should have an Amazon manager say X, Y, and Z. What we do have is through plaintiff's own words that through his deposition, and I can quote his deposition. So when I asked him, so the parking lot where this accident occurred was right in front of Amazon, he replied, yes, it was the Amazon parking lot. Did only Amazon employees park there? Yes. Is that where they told you to park when you began employment? Yes. I think through his own deposition, he shows that Amazon controls the parking lot. If you look at the wording, it controls, owns, or maintains. So you only have to do one of those three. Through his own admissions, he thinks that Amazon owns the parking lot because it was the Amazon parking lot. So the only evidence we have on the record through his own testimony is that it is under his, belief that Amazon owns it. And even if Amazon didn't own it, for argument's sake, that Amazon exerts the amount of control necessary for the workers' comp to apply to this parking lot.
All right, Ms. Davis-Campos.
Thank you, Your Honor. So our issue is that the plaintiff is not a proper person to establish ownership, maintenance, or control. In his deposition, Mr. Gaither testified he is an hourly employee with Amazon who is a picker, or who was a picker, and who operated a forklift. He can testify as to his understanding, but that has no legal effect on who actually legally owns, operates, or maintains that parking lot. That would need to come from someone higher up in Amazon. So to the extent that the parking lot rule may or may not apply in this case, there needs to be some competent evidence from someone other than an hourly employee that that is in fact the case. That would be, I remember as a law student parking in what was considered the designated student parking lot. I was told by Mercer, this is the student parking lot. That doesn't necessarily mean that Mercer owns that, controls, or maintains that parking lot. That's simply just what Mercer faculty is telling me to do. So Mr. Gaither parks there and believes it may or may not be Amazon's parking lot because that's what he was told. But that doesn't bear any weight on the legal significance of who owns, operates, or maintains this parking lot. And that is the law that applies in the parking lot exception. So we just don't think that the plaintiff is going to be the right person to testify or give any legal effect to who owns, operates, or maintains that parking lot.
All right, Ms. Rodriguez.
Going on to that, by the plaintiff being told by an Amazon person that they have to park here, this is where Amazon employees park, Amazon itself is exerting control over who parks there. And control is all that's necessary. And as for the summary judgment, they have not proven any disputed facts as to whether Amazon doesn't own or control this parking lot. What we have on the record is plaintiff statements that Amazon not only owns and exerts control over who parks in this parking lot, because it is only Amazon employees park there. It is 100 feet from the Amazon building. And at the beginning of employment, the Amazon employees are told to park there. So Amazon, by its representatives to the plaintiff, is controlling the parking lot. They're telling people who to park there, and there's no outside influences or outside testimony or other evidence that this is not owned and controlled and otherwise maintained by another entity other than Amazon.
All right. Anybody want to add in anything extra?
I have one thing, Your Honor, if I may. So there is the case that was cited in our brief, Tate versus Bruno's Inc. Food Max. That is a case where the employer told the employee to park in that parking lot. And then the Court of Appeals found that is not necessarily instructive, because that was a parking lot that other people use. Just because an employer tells someone to park somewhere doesn't mean the employer exerts the necessary legal control, maintenance, or ownership of the parking lot.
Correct, but your client though said that when asked, did anybody else park there? And he said no.
And I believe that's based on his belief, but I don't know whether not. I'm not saying that he may not know the full facts.
Sure, true, but well, okay, yeah, I get your point. But Ms. Rodriguez, you get the last word.
You know, if there was other facts to dispute it, they should have put that in the response brief. That's my last word, I guess.
Yeah, well, I don't like granting motions for summary judgment because I don't like disposing of cases in any way other than through a jury. But I think it's clear that it would be a weird situation if Amazon did not control their own parking lot, especially when there's competent testimony that says that only Amazon employees park there. Could they be wrong? Absolutely. But then also you could call Jeff Bezos and he could be wrong also. That doesn't necessarily, it's not necessarily conclusive, but it is evidence. And so the court's constrained to use the evidence that's before it, and the testimony of one witness, as you know, is sufficient, if believed, is sufficient to establish a fact. And I think the facts that have been established and haven't been refuted is that Amazon does control this parking lot, that other people do not park there. This is where he was told where to park. It's 100 feet from the entrance. There's no evidence in the record the court's aware of that says that, or would even imply, I think, that they did not control the parking lot. And I think defense counsel is right that control is all that is necessary in order for it to comply with the parking lot rule in workers' compensation. So unfortunately, I'm constrained to grant the motion for summary judgment. Obviously, if the court is incorrect in this analysis, and the Court of Appeals will gladly correct me, as they have done before in the past on occasion. Fortunately, it's been relatively rare, but it does happen. So the exceptions to the court's ruling are continuing objections for purposes of appeal, and so this will be off the calendar, and we'll see if there's an appeal, if the Court of Appeals agrees or disagrees, and if they disagree, then we'll get the band together. So, anything else about this particular case?
Nothing at this time, Your Honor.
All right. Well, I appreciate you all getting together. Courtney, did you get everything? Everything good?
Yes, sir. Everything was perfect.
All right. Did Miss Davis Campos, do you want Ms. Bridges' contact information? Are you going to take care of that as far as getting a transcript and all that?
I'll go ahead and take it down in case we do need it.
Okay. All right. Courtney?
Yes, sir.
Give her your contact here. Just a phone number is probably fine.
Yeah, phone or email is fine.
Yes, ma'am. My phone number is 912-656-4621. And my email is Courtney, Courtney, C as in cat, V as in Victor, R as in Roger @gmail.com.
All right. Thank you, Courtney.
Thank you, ma'am.
All right, I hope you all have a great rest of the week, all right?